Three high-profile U.S. Supreme Court cases result in some clear signals sent from the nation's highest court. While the cases dealt with corruption, immigration, and abortion access, there were some strong messages sent to the executive and legislative branches of government. Joining me to dissect all of this are our political and legal eagles, former Arkansas Attorney General Dustin McDaniel and KATV's lead Capitol reporter, rumored to be not necessarily number one in her law class anymore, Janelle Lilley.
Out on television.
You're still the top, though.
I'm still top
1%, we're going to say. All right.
You know, the Attorney General actually still enforces the Student Confidentiality Act, which is federal. So, I mean, you may have an action there.
That's good. Thank you for having my back there.
Let's begin with the U.S. Supreme Court. The McDaniel case is the one I want to start with. The former Virginia governor cleared on corruption charges, a corruption conviction, because the Supreme Court did what, Janelle?
Well, essentially, McDaniel's case hinged on two things. First of all, he said that the actions that he took were not actually executive actions. They weren't what you would consider an executive to have taken for a bribe. There is no quid pro quo there. Right. He didn't allow them access to things that he shouldn't have. And then he also argued a First Amendment case, that anything he did do would have been protected under the First Amendment. The Supreme Court didn't touch the First Amendment argument at all. But they did say that the actions that he took were not executive actions, that it wasn't something that he was not allowed to do, and so they cleared him of those charges.
You got a little personal connection to this, but what did you think of that?
Yeah.
Well, I think that we've always believed that the federal Fair Services statute was way broad. Now, the Supreme Court didn't get into whether it was unconstitutionally broad or vague, but realistically they said that you're going to have an official action, and they defined official action as taking some overt act to decide a case, controversy, matter, issue, or voting on a bill.
Insert influence in some way.
Doing something, but setting up a meeting, participating in a meeting, arranging meetings, going to dinners, even offering speeches talking about how this company here in my home state does these great things, and I hope we continue to support such companies because we need innovation. That's political talk that's part of the political process,
so
not a crime.
What are the ramifications for Arkansas out of that case?
Well, I think what that does is it sends a message to the feds saying, if you're going to indict someone on this, if you're going to go after these charges, you better be sure that you have a case with an official action. Just puffery and what they do is, as far as setting up meetings and stuff, is not going to be enough. We need something solid, and they really defined what the official action, what they would and would not accept under that.
Well, I did sign a brief along with ultimately 83 state former attorneys general, Republicans and Democrats, in defense of Governor McDaniel, not defending the judgment that he exercised or whether it was a good idea for him to take $175,000 worth of gifts, ranging from his daughter's wedding reception to his wife's wardrobe. Obviously, that's not good.
Moral ramifications versus actual.
Appearance of conflict, public trust, integrity of the office. Bob can't defend any of those things. I mean, he just can't. But there's a difference between political, embarrassment and what you can put in front of a federal grand jury. Everybody in Little Rock knows that the U.S. Attorney's Office has been having meetings and taking proffers from witnesses, and we assume conducting grand jury testimony. They want to bring a federal corruption indictment against one or more of our public officials, and we see a lot of news fodder that's pushing it. It's going to take more than just kind of unseemly looking politics, coincidental contributions, even gifts. The Supreme Court has said you're going to have to establish that someone actually took an action that was official, and it was a quid pro quo in order to establish a corruption charge.
Let's jump to another ruling here. Abortion access was at the center of a Texas case here. The Supreme Court said that there's a series of obstacles to some, medical safeguards to others, depending on your political position here, restricted access to abortion clinics and to procedures. This was a huge victory for the pro-choice movement. What are the Arkansas ramifications of this ruling?
Well, first of all, it gave the 1992 ruling a lot of teeth that they had in saying that any ramifications can't really have outcomes that will prohibit a woman's access. So requiring a doctor to have admission privileges at a hospital is one of those things that would it effectively closed down 50% of the abortion clinics in Texas. And as far as like Arkansas ramifications, you could speak to this probably better than I could, but I know we have a current case that is similar in some ways.
Well, Planned Parenthood versus Casey is what established modern jurisprudence on how Roe v. Wade is interpreted. So it set an established right for a woman that cannot be impeded by undue burden, those being the magic words. It also set the time at which the rights of the unborn child begin, and that being at the point of viability.
Right.
So we've had two big laws in Arkansas that were passed, one being the fetal heartbeat bill, one being the fetal pain bills, sometimes known as the 12-week, 20-week bills. Both of them, the legislature pretty well knew they were not going to survive constitutional muster when they passed it, but they believe, much like slavery once being constitutional, you've got to keep going, you've got to keep fighting, and sooner or later you're going to win. But they were struck down, it was expensive, and we have another one that's not exactly like the Texas law, but it's close, and it most likely will not survive muster either.
So 30 seconds, is it going to stop the legislature from passing these types of
No.
laws?
No, I'm afraid it doesn't.
No,
It
they won't
doesn't.
do it. All right, so we'll be back with that. Look, let's, you guys stick around. Let's do a web extra when we go off the air here, and we'll talk about a couple other cases that are up there too. Will you do that?
Yep.
Absolutely.
All right, Dustin McDaniel, Janelle Lilley, thank you so much. Appreciate you. And welcome back to our Web Extra. Our political roundtable with Dustin McDaniel and Janelle Lilley continues. All right, we didn't get to everything on air, so let's go with our, let's go with another ruling. Yeah, let's go with immigration on and the Supreme Court ruling there. Republicans, including many in Congress, celebrated the immigration ruling from the Supreme Court that basically President Obama had overstepped his boundaries with executive authority. But you see, Dustin, you see that there was a little bit stronger message in this for the Congress.
Well, first of all, you got to understand we're talking about a one-line opinion because it was a 4-4 split. So we don't have a real answer to the question that the Scalia court actually gave a writ of certiorari to decide. So we go back. My friend Ken Paxton, who himself is under indictment in Texas, the Attorney General of Texas.
A lot of friends under indictment. What's up with this?
You know, AGs either go on to higher office or they get indicted. Very few find themselves in private practice like me.
Yeah.
So, I mean, there they are in Texas. It's a no-brainer. They're going to challenge the Obama administration's immigration policy, and frankly, it was no big surprise that their Circuit Court of Appeals upheld the lower court striking it down. So it was obviously given a writ of certiorari because the Supreme Court needed to decide the question. We don't have a full Supreme Court. We don't have a ninth justice to break this tie one way or the other. But the bottom line from the lower court was maybe Congress has completely fallen asleep at the switch. Maybe they've abdicated their responsibilities and duties to do something, but simply the inaction of one branch of government doesn't allow the other branch, the executive branch in this case, to just step in and assume their duties. It doesn't work like that.
A tie vote makes no law is, you know, a great way to think about it, because the truth is it doesn't. The 4-4 split makes no binding precedent, and so the next president, whomever he or she may be, can come in and do another executive action, and it will not in any way impede or impact that.
All right, open call for the rest of our Web Extra here. You get to pick a court ruling, you get to pick a court ruling to talk about.
Okay, I'm going to
You go
pick,
first.
I'll pick affirmative action.
Go for it.
All right, first of all, this was an interesting case. I mentioned to you, I thought it was funny that Justice Kennedy didn't write the opinion on this, and you said he can't write everything.
Yeah, well, he can't.
But it was interesting to see the way that he voted on this. It was a kind of a resounding vote, and I, in particular, am interested to see what the effects are long term. I want to get your take on that.
Well, the court has said that the only way we're going to get race out of our law and out of our society is to quit using race as a factor in our law and in our society. And so to some extent this was a shift of thinking when they said, but wait a minute, we don't mean that we're blind, and it doesn't mean that we are immune to the notion that some racial imbalances still deserve to be addressed. And so they said that a college admission program with a racial consideration was in and of itself not a violation of the 14th Amendment. I think that it's a relatively moderate stance, and it tells us that even a conservative court is not going to completely abandon racial considerations.
All right, open call for you.
Well, I thought it was interesting. You know, America. Everybody that knows me knows that I am pro Second Amendment. Know that I love to hunt and I collect guns, and I'm pro Second Amendment. But I also think that we have to recognize that society is evolving, and when we reach the point under the notion of being pro Second Amendment that we can't even vote to say that people who are too great a danger to be on an airplane shouldn't be able to also have free access to heavy weaponry. I think that maybe we've lost a little bit of perspective. So you had two guys in Maine who challenged a 20-year-old congressional act saying that misdemeanor violations for domestic violence convictions would prohibit you from buying a gun. And they said, look, it's a misdemeanor, it's not a felony. The fact that it was a domestic violence and I hit my wife instead of a stranger shouldn't mean that somehow or another I shouldn't buy a gun. And the Supreme Court said no, Congress does have a just cause to identify certain crimes that should prohibit a person from having their full exercise of their Second Amendment rights. Congress is not paying any attention to what the Supreme Court's saying. The Supreme Court's paying attention to what the people of the United States are saying.
I think just as a news reporter, we see a lot of domestic violence and it escalates a lot. So it did seem that there was a logical connection between the law and the restriction. And just as a reporter's standpoint, I mean, a lot of the gun crime that we see is domestic. It's, you know, within family members, or it happens to be at a household party where you know each other. And so it certainly is something for them to consider, and the Supreme Court backed that up.
You don't even need to go back to law school. We will just have a legal roundtable every week.
Give me my law degree right now.
So, all right, Janelle, Dustin, thank y'all both very much. Appreciate you.
Thank you.
Thanks for watching this Web Extra. You can keep up with the latest business and political headlines each and every day at talkbusiness.net. Thanks for watching.